However, the committee may determine or agree to a request to have evidence heard in camera. Information on procedural rules governing public hearings and claims of public interest immunity have been provided to witnesses and are available from the Secretariat. Any witness called to answer a question for the first time should state their full name and the capacity in which they appear. Witnesses should speak clearly to assist Hansard to record proceedings. To assist with the recording of this hearing, please ensure your microphone is set to mute when you are not speaking. I remind media representatives listening to follow the media guidelines and any instructions of the committee secretariat. I ask everyone to ensure they have switched off or turned their mobile phones to silent. I suggest to witnesses that any questions on notice asked of you should be noted by you today, and the Secretariat will send the Hansard transcript to you as soon as it is available. I advise you that any responses to questions on notice should be sent to the Secretariat by 4 p.m, Australian Eastern Daylight Saving Time, Friday, 12 November 2021, that is this week. There will be no extensions to this timeframe due to the 18 November reporting date. I now welcome the representatives from the Australian Workers' Union and Offshore Alliance, the Maritime Union of Australia and Offshore Alliance, the Electrical Trades Union of Australia and the Australian Council of Trade Unions. So as I understand it, we've been given a list of the order of appearance and the opening statements. So if I could ask Mr. Adrian Evans, Deputy National Secretary of the Maritime Union of Australia and Offshore Alliance. Are you there, Mr. Evans?
Yes, I am, Senator.
Okay. Do you have an opening statement to give us?
Yes, thank you, Senator Scarron. I thank the committee for the opportunity to appear.
Thank you.
We'll be appearing as a group so as to avoid covering the same ground as far as that is possible.
Yep.
Just to clarify, my name's Adrian Evans. I'm actually the Assistant National Secretary of the Maritime Union of Australia. I lead the union's work in the offshore oil and gas industry, along with our members who work in a highly skilled maritime crew and specialist divers in the offshore oil and gas industry, which the bill applies to. And to clarify, the Offshore Alliance between the MUA and the AWU was established in 2018. Since then, the Alliance has attracted around 2,000 members working in production platforms and other areas of work within the Alliance scope. We've established many new agreements covering these workers and also are active in raising health and safety issues within the oil and gas regulator, NOPSEMA. To be clear, we welcome and support the bill and the levy and understand it is part of the package of improvements to decommissioning requirements the government has put forward in legislation that is passed in August and NOPSEMA policies and directions. We do note, however, that one significant part of the enhanced decommissioning package remains missing in action. The requirements for the oil and gas companies to have financial security, to have their decommissioning liabilities covered. This is critically important given that the NOPSEMA Advisory Board has identified that the industry appears to not have had removal as the default consideration in their planning, nor have assets been valued on the basis of full removal. And that in some cases, maintenance has not taken place to allow removal. We urge senators to make inquiries about this. The MUA and Offshore Alliance members will be the people carrying out the work funded by this levy. We currently have members working on the Northern Endeavour, the ex-Woodside floating production storage and offtake vessel, which is a FPSO acronym, currently stationed on the Laminaria and Carolina oil fields. Our members would also be crewing the vessels that will ensure the Northern Endeavour is towed to a yard where it can safely be dismantled. We'll be crewing the vessels that would dismantle and remove the mooring and structures that take the oil from the seafloor up to the Northern Endeavour. We'll be doing the highly specialised dive work at significant depth to permanently plug the oil wells and remove the umbilicals and pipelines to the oil field. Construction of these facilities is hazardous work and decommissioning will be even more so, and it'll be specialised. The problem is there is every incentive for employers to cut corners to win contracts. We've already seen that incident in WA while the Simbad platform was being removed. which could have resulted in multiple fatalities. Decommissioning is a growing challenge for the Australian oil and gas industry, and was recently estimated that removal of oil and gas equipment and plugging wells will cost around 52 billion Australian dollars. There's currently 1,008 offshore wells, 57 fixed facilities, 6,500 kilometres of pipeline, 1,500 kilometres of umbilicals, and some 535 subsea structures such as manifolds. Most of the $50 billion spend will be on labour costs, along with vessel hire, but that's a lot of jobs. And a lot of this work needs to start now, as we estimate that at least 200 oil and gas wells and 10 platforms are already disused, some for 10 years or more. The government has indicated in their tender document for decommissioning of the Northern Endeavour that the project will set the standard for future similar activities in Australian waters. This levy is an opportunity to set this decommissioning work up in the right way to maximise the jobs for Australian oil and gas workers, the return to the Australian economy, and to ensure the best environmental and safety standards. Oil and gas workers want to do our part and utilise our specialist skills to ensure that we prevent pollution to the marine environment we work in. These jobs are also particularly important to the workforce as the world decarbonises, creating an uncertain future for our jobs and our industry. However, we are concerned that the bill, measures in the bill could have the opposite effect. The bill invents a new definition of decommissioning. Instead of using the established removal as the framework under the OPGGS Act, there appears to be no legally binding framework for either safety compliance or the environmental plan and the environmental compliance of this bill. The Resources Minister has a unilateral ability to reduce the amount of the levy and end it early, and we are quite sure that they will be under significant pressure from industry to do so. We also need to consider the impact on East Timor and Indonesia, located not too far from these oil fields. In March this year, some 15,000 seaweed farmers in Indonesia won millions in compensation because their crops have still not fully recovered after the 2009 Montara oil spill. International conventions and Australian law require us to remove oil and gas infrastructure, and this must be done properly. In our submission, we put forward a package of amendments which aim to improve safety and environmental regulation for the Northern Endeavour, and to use the opportunity for this levy to set up Australia's decommissioning task in the right way. Taylor Rundle from the AWU will talk to the specifics of those amendments, but they include measures to ensure 1, legally binding safety and environmental oversight, 2, the removal of all oil and gas equipment from the oil fields as per Australian legislation and international conventions, 3, that the levy is not ended before the work is properly complete, 4, that the jobs and economic benefit to Australia are maximised for this and future decommissioning projects, including setting up an Australian decommissioning yard, and 5, proper reporting and transparency. Zach Duncalfe from the AWU will speak next. He will cover off the issues currently facing our members on the Northern Endeavour. Then Matt Murphy from the ETU will cover electrical safety issues and the need for proper removal and disposal of hazardous materials that can be found on facilities like the Northern Endeavour. Then Taylor will cover the amendments we are recommending, and Liam O'Brien from the ACTU will sum up. I hope that is acceptable to the committee, and I once again thank you all for the opportunity to appear today.
Thank you very much, Mr. Evans, and I think your order of proceedings makes sense. So we'll, without further ado, we'll go to Mr. Duncalfe. Can you hear us?
I can. Thank you very much. Can you hear me?
Yes, I can. So over to you, please.
Excellent. So good afternoon, and thank you for the opportunity to appear. So my name is Zach Duncalfe. I appear as a representative of the Australian Workers Union. The AWU has broad industry coverage of the offshore oil and gas sector in Australia, and we've got thousands of members engaged in this sector. For the past few years, the AWU and the MUA in Western Australia have worked closely and collaboratively for the benefit of the workers in offshore oil and gas, and we established the Offshore Alliance, which has made a submission to this inquiry. As part of my role with the AWU, I coordinate the Offshore Alliance campaign and represent the Offshore Alliance membership in collective matters before the Fair Work Commission. As a result, I work closely with the Offshore Alliance organisers and members, and I'm aware of the issues facing workers in the offshore oil and gas sector. The AWU has members working for contractors on the Northern Endeavour FPSO, including a significant number engaged by the contractor providing the operations and maintenance services, which is Upstream Production Solutions. Recently, the AWU has been informed by members on board the Northern Endeavour of a number of worrying matters, including those addressed in the Offshore Alliance submission to this inquiry. I'll go through those one by one with a little bit more background now. So firstly, we have a serious injury that was sustained in September of this year by an AWU member, including fractured ribs, torn tendons, and a spinal fracture due to a fall caused by unsafe flooring on the facility. It was a hazard that had been raised with management previously, and apparently no action had been taken in relation to it at the time of the injury. Since the injury, the union's been informed that the floor has been haphazardly quote unquote fixed, but still not to an acceptable standard. So that still remains a hazard for those working on the facility. We've also had reports from members of unacceptable basic offshore safety induction and training qualification dispensations. So these types of dispensations are generally quite rare and used in extenuating circumstances for specialist personnel who then need to be shadowed during their time on a facility if they don't have that qualification. We've had reports made to us that a member of management on board the Northern Endeavour is granting these Boziet dispensations to office staff, including the company's health, safety and environment officer and others. We believe this is a poor reflection of management's attitude to safety, and also perhaps due to management's belief that they don't currently operate in a strict regulatory environment, which currently appears to be true due to the bankruptcy and administration of TS-OGA. We've also had reports of insufficient life rafts and fast rescue craft on board the facility for the number of persons on board, which is obviously worrying. And there's also an openly hostile attitude of at least one member of management on board the Northern Endeavour towards unions and freedom of association, which was conveyed to workers at a toolbox meeting on board the facility. The comments of the member of management, which included statements similar to "this is not a union vessel and will never be a union vessel," and also "anyone who wants to preach unionism can expletive off and take that propaganda with them," were apparently inspired by employees posting a bargaining petition to a notice board on the Endeavour, and the AWU sending correspondence to UPS requesting that the company commence bargaining for an enterprise agreement to cover their workers on board the facility. The approach by UPS to collective bargaining under the Fair Work Act is another worrying matter for the AWU and the Offshore Alliance, particularly if the Northern Endeavour is to serve as a best practice decommission, as it has been spruiked. The current enterprise agreement applying to UPS employees on the Northern Endeavour expired over a year and a half ago. And the AWU has requested that UPS commence bargaining. We made that request on the 8th of October this year, and we received no response to that request. On the 14th of October, the AWU sent UPS further correspondence in response to the reports of the member of management statements at the toolbox meeting, reminding them of the rights of their employees and also its obligations as an employer. Again, no response was received. On the 22nd of October this year, the AWU sent further correspondence to UPS, requesting that it commence bargaining for an enterprise agreement under the provisions of the Fair Work Act. On the 27th of October, a response was received and UPS declined that request. 2 days after this response was received, members reported that a member of UPS management visited the facility to inform employees that the company did not want to negotiate an enterprise agreement with union involvement because it would be quote unquote quicker to negotiate an enterprise agreement without the union. On the 3rd of November of this year, the AWU applied to the Fair Work Commission for a majority support determination, seeing no other option to get the company to the table. So we're seeking an order from the Commission that the company commence bargaining with employees and their bargaining representatives for a new enterprise agreement. And we don't think that it should be that hard. In the experience of the AWU, Employers that take a hostile approach to workers joining unions and having union representation are generally more likely to establish a poor culture at the workplace, and that's particularly in regard to safety. On the basis that the Australian government is footing the bill for the decommission, it is likely that the decommissioning of the Northern Endeavour will be used as a yardstick to measure future decommissioning projects against. The current conditions on the Northern Endeavour and reported approach by management to safety and freedom of association are far from what anyone would label best practice. It's clear to us, and it should be, we believe, clear to anyone with the facts, that significant improvement to the current operating practices and conditions on the Northern Endeavour need to be made. I'll now hand off to Matt Murphy from the ETU. Thank you for your time.
Okay, thank you, Mr. Duncalfe. So, Mr. Murphy, are you there?
Yes, I am, Senator.
Over to you.
Thanks, Senator, and thanks, Mr. Duncalfe, for handing off to me. Senators, today I've been asked to speak to you with respect to electrical hazards and environmental hazards arising from those matters. My name is Matt Murphy. I'm the National Industry Coordinator for the ETU. The ETU is a union of more than 60,000 members, both on and offshore within the Commonwealth, with a particular interest in the electrical contracting, electrical power and engineering industries. It's under engineering that offshore oil and gas falls within our organisation. And as a result, I'm the official responsible for it. The concerns that I've been asked to relate to you go to a number of matters, but first off, I'd simply say that I do support the submissions of the MUA and AWU and welcome the intent of the bill. However, issues that arise for us are in the nature of electrical hazards. One of the concerns we have is that due to the remoteness perhaps of Northern Endeavour, the application of Australian standards and licensing and qualifications may not as be stringent as what may be experienced on shore. It is imperative in our view that any decommissioning work done on Northern Endeavour or on any vessel whatsoever be completed by appropriately qualified and licensed electrical workers. It should be clarified with respect to the Northern Endeavour, the application of Australian standards subject to the location of the Northern Endeavour at any particular time with respect to the borders of the Commonwealth. And we do have, as I said, some concerns about the offshore nature of the Northern Endeavour being out of sight and out of mind, and the enforceability of electrical standards in the decommissioning work. A number of the issues that relate to decommissioning, noting that the Northern Endeavour was built in Korea, we're concerned about the presence of offensive materials such as asbestos. In a number of electrical appliances, there may be a substance called PCBs, polychlorinated biphenyls. These matters, if not these types of materials, if not properly decommissioned and disposed of, if the whole vessel is not disposed of correctly and appropriately, cause a massive risk to workers and the environment. So legacy materials on board are an issue for us. The nature of the installation may or may not also have similar sort of legacy materials. Asbestos may or may not be used in some of the fireproof circuitry, and that is a concern that we have. One of the other concerns that we have with respect to decommissioning is the supply of electricity to the vessel at any particular time, and the nature of temporary wiring. Adequate lighting for work clearly needs to be adequate. Australian standards provide, particularly in relation to emergency egress, a minimum of 20 lux lighting for emergency egress from building and construction sites. These standards should equally apply to Northern Endeavour, and adequate lighting for emergency egress and indeed normal work should apply. That'll need to be installed by qualified electricians and maintained by them. So the installation of temporary power and light needs to be done by licensed and qualified electricians, needs to be maintained by them. Legacy materials and equipment, the environmental risks of that need to be dealt with appropriately and correct records kept. The final issue, or the final two issues I'd like to deal with, is the recording of works and drawings. I'm handing off the vessel from one owner to another, engagement of contractors and subcontractors, needs to be considered with respect to the record of works executed on the vessel. It is a personal interest to me, and through personal experience, having worked in the industry, been exposed to electric shocks by work being completed in substations, that wasn't in accordance with the diagrams held in that substation. This can equally apply on vessels. So works is executed and appropriate records, especially electronic ones, need to be up to date to ensure that those working on the vessel have an adequate record of the current status of the electrical wiring. The last matter concerns particularly isolation and earthing. All electrical work other than testing must be carried out in a isolated and earthed condition with codes of practice that apply onshore in the various state jurisdictions. These also need to be noted for the offshore nature of the Northern Endeavour and the other vessels that this legislation may apply to. Isolation and earthing, again, as a subset of the record of works and drawings, must be recorded adequately and ensure that there is no floating voltage available between earth and neutral, as a technical term, that could endanger the lives not just of the qualified electricians working on it, but other tradespeople and workers engaged to decommission the vessel. There are numerous technical challenges working with neutral and earth systems on vessels. Clearly, it's not something that you can adequately earth as an onshore installation, and these can give rise to dangerous voltages arising on neutral and earth circuits. These are matters that can only be adequately dealt with by properly trained, qualified and licensed tradespeople, and any activities conducted on the Northern Endeavour or similar vessels with respect to decommissioning disposal must be undertaken by these people. Senators, I'm quite grateful for the opportunity to provide this brief statement, and thank you for that. And I'm happy to deal with any questions, queries, doubtful points you might have during the course of this discussion, this hearing, or at any subsequent hearing or request that you might make. I stand ready to assist in any way possible. I'll hand to Mr. Rendell from the AWU with the consent of you, Senator.
Okay, thank you, Mr. Murphy. Mr. Rundell, are you there? Can you hear us?
I am. Can you hear me?
I can. Over to you.
Very good. Thank you, Senator Scard, the senators on the committee, and to my union colleagues. My name is Taylor Rundell. I advise the AWU on a range of areas of industry policy, including oil and gas. As Adrian noted at the start of this hearing, the Offshore Alliance definitely supports a levy to fund the decommissioning of the Northern Endeavour. We've supported stronger measures to essentially ensure that decommissioning liabilities aren't avoided, and particularly where a title holder ends up in liquidation or otherwise unable to pay. However, at the moment, we think the measures are pretty bare bones. They establish a levy to fund decommissioning activity, but they don't really go much further in that. So we have some concerns that we believe would allow this measure to set the standard for the growing challenge of decommissioning. The first of these is that there is no safety regulator for this decommissioning activity from a legal perspective, because there isn't a title holder. Under the OPGGS Act at the moment, there needs to be a title holder for NOPSEMA to have jurisdiction. And because the Northern Endeavour's title holder is now insolvent, there isn't a title holder and there's no NOPSEMA regulation as a result. So DISA is currently in charge of the decommissioning task with NOPSEMA as an advisor on its task force. This puts it in the slightly unusual situation of facing less regulation than a private company doing the same activity. So our recommendation is that this legislation should specify that NOPSEMA is the regulator, and certainly that the exact set of legislation that applies to this activity, whether it's under the OPGGS Act or under the EPBC Act or whatever relevant environmental regulation might apply, it's set out in the Act. The second is that we see full removal of all infrastructure from the Northern Endeavour as the baseline to be achieved. So the OPGGS Act and NOPSEMA's policies refer to removal of infrastructure. They don't define the term decommissioning, whereas this legislation does define the term decommissioning, but it expands it. It says removal or any other treatment of infrastructure. Ordinarily, under NOPSEMA policy, you wouldn't be able to deviate from the requirement to remove infrastructure unless you had been given specific approval to do so. So we are a bit concerned that using a broader definition in this legislation would expand the meaning of decommissioning in all contexts. Because this legislation is about funding the decommissioning, we suggest confining that definition to decommissioning costs and then using the standing policies of NOPSEMA and the provisions of the OPGGS Act to guide it. And we also suggest putting in an explicit object into the Act and setting out a purpose for the levy, which sets removal of infrastructure as the baseline. The third area that we make a recommendation on is about the time frame for decommissioning. So to put it lightly, the time frame is set for the end of this levy by 2029, but we have no idea whether the task will be done by 2029. And further, as Adrian's mentioned, the Resources Minister can decide that the levy ends at any point, and he'll be under great pressure to do so. So the levy should apply while it's needed. There shouldn't be an opportunity to end it before the need for it is gone. Our fourth policy recommendation is one around this idea of setting the standard. We know that the decommissioning task is growing over time, and we see that there's an opportunity to use this decommissioning project as the start of an Australian decommissioning industry. In particular, we'd like to see a dedicated decommissioning yard here in Australia with training opportunities attached to it. Otherwise, a large part of this work in the future is not going to be done here in Australia and is likely to go to Southeast Asia. We'd like to see the government work with industry to establish training packages and potentially fund an institution with a sort of ongoing training program. We'd also like to see the opportunities for economic benefit and job creation from this project maximised. So we'd like to see that all tenderers for this project participate in Australian industry participation plans and also comply with rigorous standards for local industry. We set those out in more detail in the submission, but those go to making sure that the operators are fit and proper, and also that they take whatever opportunity they can to develop Australian jobs. And finally, the current specification of the levy in the legislation doesn't require much in the way of reporting or transparency on the collection of the levy or on what DISA does in decommissioning with the revenue they've earned from the levy. So we'd just like to see that those activities are reported on so that both industry workers and those paying the levy understand what's happening as a result of it, that it's not just money going into a black box. At this point, I'll pass on to Liam O'Brien from the ACTU. And thank you for your time, Senators.
Thank you, Mr. Rundell. Mr. O'Brien, can you hear us?
I can, Senator.
Excellent. Over to you.
Thank you, Senator, and thank you to the other senators on the committee and also to my colleagues. I would also like to state at the outset that the ACTU does support the bill, and we also agree that this is a starting point. There are some significant gaps that need to be addressed. As you can appreciate, offshore oil and gas work is highly hazardous work. And when it comes to decommissioning, it is obviously magnified in terms of the hazards and risks that workers are exposed to. This is not just because the removal of hundreds of thousands of tonnes of equipment, both topside and subsea, presents significant risks to workers based on the state of repair of equipment and the issues around access of that equipment, but also in relation to the economic situation, which I'm sure, as others have noted, is very aware to the committee that decommissioning of assets is not something that businesses or operators will profit from, and it therefore is highly likely that it's exposed to cost-cutting practices. And others have talked about experiences elsewhere throughout the industry about how this has often played out, but it should not be understated that the issues that face decommissioning of these assets are really increased by the economic situation. I'd also like to talk about the fact that we really need to see this as an opportunity, not just to implement appropriate safeguards and regulations that protect workers and indeed the environment, but that we also see, as my colleague previously mentioned, the opportunity seized in relation to the jobs and the necessary capacity for Australian industry in order to decommission the assets that are needed over the coming decades. The first of those really is, given the size of the future work, making sure that Australia has that capacity. And what was mentioned previously about the establishment of an Australian decommissioning yard supported by Australian industry is very critical in terms of making sure that we can achieve the task of decommissioning assets over the coming decades. I'd also like to endorse the need to include Australian industry participation plans for all work over $1 million to ensure that we do maximise the economic benefits to Australians and Australian workers. We also need to make sure that we are using appropriately skilled workers and operators through this next phase. As has been previously reported by my colleagues, it is absolutely essential that appropriately skilled and qualified workers are used to do this work. And that is why it should be a requirement going forward that we have a minimum of 10 years experience for those that are engaging in decommissioning work. There is a significant volume of work that is due to come in the coming decades, and we must make sure that Australia has the domestic capacity to meet those challenges. I think, Senators, that probably summarises, and I'm very conscious of the time and giving the opportunity to ask some questions of both myself and indeed my colleagues, the importance of this. The one final overarching comment I would make really goes to the coverage of our work health and safety regime and making sure that those that are responsible for managing these assets are held accountable under the appropriate health and safety regime. And I note what's been previously said about the need for NOPSEMA to have the appropriate regulatory powers to ensure compliance. As my colleague Zach Duncalfe said, there have already been a significant number of incidents on the Northern Endeavour, and the very nature of decommissioning work lends itself to be highly risky and hazardous work that we should not at any stage compromise the ability of regulators to take the necessary action to protect workers' health and safety and the environment. Thank you, Senator.
Thank you very much, Mr. O'Brien. We do have really limited time now. I found those opening statements very, very useful, but I would like to provide an opportunity for my colleagues on the committee to ask some questions before we have to move on to our next segment of witnesses. So, Mr. Senator Chisholm, you have some questions for the witnesses?
I do. I'll try and keep it limited, but there are lots of issues to cover. I might start with the issue around NOPSEMA. So in the tender document, NOPSEMA's website refers to the Northern Endeavour facility no longer being regulated under the OPGGS Act framework. Under this bill, who do you understand has regulatory cover of the decommissioning?
I might take that. My name is Penny Howard. I'm the National Research Officer for the Maritime Union, and in that capacity also do work with the Offshore Alliance and the AWU. It's unclear to us. The bill doesn't nominate who is the regulator, either for the safety or the work or setting the plan. It's simply not mentioned in the bill. And so that is a real concern for us. And I suggest that perhaps you could take that up with DISR and NOPSEMA when they appear later on, because it appears to us that there isn't a clear. We understand that NOPSEMA and DISR are overseeing it, but in terms of they're not the ones doing the work. It's contractors 500 kilometres north of the coast of Australia who'll be carrying out that work. So we really need to have good, strong enforcement practices, and we need the companies to know and understand that, and not to think that they'll be able to get away with whatever they like out there.
Is there any reason why you think it isn't clear that NOPSEMA is given responsibility for this?
I don't know. That hard for us to say. I think that's a question for them. I do think the government is probably under significant pressure from the rest of the oil and gas industry, who were not very keen on the concept of this levy at all, because they would effectively have to pay to decommission Woodside's former assets. So I suspect they're under a lot of pressure to reduce the costs and the expenditure on this levy, or maybe they just thought it was too difficult. Either way, we think it's a problem that does need to be urgently addressed.
Thanks, Chair. I'll leave it there. I've got some other questions we'll put on notice.
Thank you, Senator Chisholm. Senator Patrick.
Yeah, thank you very much. Firstly, did the unions actually make any submission to the consultation process?
Yes, we filed our submission on Friday, and it's up on the website.
No, so I'm talking about the department's consultation that it ran earlier in the process.
No, that was a bit unusual. We made a consultation to the department's enhanced decommissioning framework consultation that ran December, January last year, and that was fairly widely advertised and did have a reasonable length of time attached to it. Quite unusually, when submissions opened on these other aspects of the decommissioning task, they're actually very brief consultation periods, and we weren't notified of them either. There wasn't any notification sent to any of our organisations about them, and because the period was only a couple of weeks for each of them, we did actually miss them. It was a missed opportunity on our part, but we also think that the government should have made a greater attempt to contact organisations representing the workforce carrying out these projects.
So the recommendations that you've put to this committee have not been seen by the department. That's essentially what you're saying.
Yes,
okay.
we have put submissions to NOPSEMA around other aspects of their decommissioning policy, and of course to DISR on their enhanced decommissioning framework, but not specifically on this bill.
Now, I understand that NOPSEMA, and this understanding is gathered from estimates hearings, are not the regulator. They give advice to the Northern Endeavour Task Force, and there's been a sign-off that somehow transfers responsibility to the minister. In that respect, who's the right body to advise on things like leaving components on the seafloor? Is it NOPSEMA still, or is it that sort of decision making? Should that rest somewhere else, or advice be taken from somewhere else?
Well, certainly, as it stands right now for other projects, the proponents are required to file an environmental plan, and an environmental plan that meets the requirement for full removal. And if they want to file a deviation from removal requirements, they need to justify that separately, and NOPSEMA needs to approve that. So they are a reasonable body to oversee that. But that process needs to be a transparent process, and one that other organisations have the ability to scrutinise and make input on, and it doesn't seem there's any transparency in the current process or ability to issue directions, issue prohibition notices, or issue fines if there are any problems with the way the work is carried out, either from a safety or environmental perspective.
Okay, there's a submission that's now in by APPIA that suggests quite the contrary to your organisation, that the government will keep this levy going for some period of time, and indeed there should be some statutory point at which the levy is stopped. What do you think is the realistic time frame for the decommissioning? And this, in some sense, goes to my last question. Is there some sort of technical trigger that tells us that the job is done, or is that also sort of subjective on the basis of your last answer?
That is a question that I actually had in reading this bill as well. I think it's a critically important question to answer, and I'd encourage you to raise that with DISER and with NOPSEMA. My understanding is that I've had a look at the directions that NOPSEMA have issued for the decommissioning work undertaken by other companies. So there's a series of steps that are involved in there, and work that needs to be completed to the satisfaction of NOPSEMA. There's about 5 different aspects to it, from plugging the wells, removing facilities, removing subsea equipment, preserving the natural resources of the area, and making good any damage to the sea floor and subsoil of the sea floor. And all of those things are attached to the satisfaction of NOPSEMA. So there must be processes in place that they have to ensure that work is done. And I suspect that if that work is not done, then the body holding that permissioning, understand, for example, under the EPBC Act, they'd be liable for significant fines if it was shown that that work was not completed according to the plan. And that's one of our concerns. There's not that basic accountability processes in what we're looking at before us.
Okay, thank you. I've just got really one more question. I actually have lots, but we've run out of time. But and I think this Mr. Duncalfe was talking about working conditions on board the Northern Endeavour, if I recall correctly. It seems to me that UPS, if you work back through the original sort of KPMG reports as to what the cost was to run the vessel whilst in production, so this is for UPS to be running the vessel, and the cost now under the Northern Endeavour Task Force is actually higher. And that seems odd to me, noting that it's in lighthouse mode, not production mode, and then coupled with your evidence. Where's the money going?
That's a very good question, Senator. I wouldn't be able to answer that for you, but I also think that that is a very good question to be answered by someone who would know the answer. Okay, all right. So you're just confirming that there's something that doesn't quite reconcile correctly in relation to that? Yes, we're of the same opinion, Senator. All right. Thank you. That's my truncated set of questions, Chair.
Okay, thank you, Senator Patrick, and I'd like to thank the witnesses from the MUA, AWU, ETU, the Offshore Alliance collectively for appearing before us today, and thank you for the time and effort you put into your testimony, the opening statements and your submission. It's greatly appreciated. And I would ask you if you could disconnect from the video conference. You're quite welcome to follow the rest of the proceedings through the parliamentary website, but we'll move on to our next witness now. Thank you very much.
Thank you, Senator.
Thank you.
I now welcome representatives from the Wilderness Society of Australia, Inc. Thank you for appearing before the committee today, and thank you for your patience. We're just 5 minutes over time. Information on procedural rules governing public hearings has been provided to the witnesses and is available from the Secretariat. If I could ask each of the witnesses from the Wilderness Society to introduce yourselves and will provide